welcome to all who are attending this TBA webinar. This is a catch-up from our last webinar on the state of the insolvency market and changes that have happened over the last few months. I'm delighted to be joined by our guests, and in particular Lord Callanan, who is very kindly standing in for Paul Scully, who was due to be with us today, but he's leading a debate for the government in the House of Commons, and so is engaged on other business. The other guests are, as per our last webinar, Prav Reddy, an insolvency lawyer and partner in Catton Muchin Rosenman, and my colleagues Andy Bailey and Dave Rutter. The running order for today's event is that we will shortly hear from Lord Callanan about his role as a business minister. I will then speak briefly about the casually named Rating Coronavirus and Director Disqualification Dissolved Companies Bill, and I know that Lord Callanan is leading that through the House of Lords. Dave will then speak about business finance in the current market, and we'll move on to the panel session, which we're giving a little more time to during this webinar. We've received a number of questions in advance of the webinar, but if you do have questions that you want to put, please use the Q&A function and we'll try to get round to them. I'd now like to introduce Lord Callanan. Lord Callanan was a member of the European Parliament from 1999 to 2014, when he was elevated to the House of Lords. Prior to being elected as an MEP, Lord Callanan had a background in engineering. He is currently Parliamentary Under-Secretary of State in BEIS as Minister for Business, Energy and Corporate Responsibility, with insolvency falling under his remit. Welcome, Lord Callanan.
Well, thank you very much indeed, Martin. It's a pleasure to be with you. And can I firstly amplify what you said earlier and give the apologies for my colleague, Paul Scully. He suffered from the problem of being summoned to Parliament. It happens to all of us, and so he's asked me if I can step in for him, and he stepped in for events for me when the same thing has happened to me in the House of Lords as well. The agenda changes from day to day, and there are urgent questions and debates and things that are inserted on the agenda, and I'm afraid our responsibility as parliamentarian is, doesn't matter what else you have in your diary, you have to jump it and get yourself to be into Parliament to be accountable, which is, I suppose, how the process should work. So I work alongside Paul. We're both ministers in BEIS. As you said, my title is Business, Energy and Corporate Responsibility. So if I give you a quick run through of what I'm doing at the moment, you mentioned, of course, the Director Disqualification Bill. So we had the second reading of that in the House of Lords last week. It's actually a bill that's shared between BEIS and MHCLG, or it's got a new name, the department now, Business Levelling Up and Local Government or something. I don't know what the acronym is for that. So they're doing all the re-rating part of it, and my bit, or rather BEIS bit, is actually quite small. It's just related to the ability to take action against directors of dissolved companies. So that will go to what's called the committee stage in the Lords, I think either next week or the week after, and then it will go through its various stages, but it's relatively uncontroversial, so we don't anticipate any particular problems with it. You also mentioned, so one of the other areas that I do have responsibility for is insolvency and Companies House. They're both under my remit, although I hasten to add that they are independent bodies. They they have the legislative freedom to take action themselves, and I can't get involved with the day-to-day operational decisions of them. I just oversee the budget and oversee the policy responsibilities for it. Other areas that I look after is in energy. I look after the heat and buildings strategy. So all of the government's clean heat programs, we just announced our heat and building strategy earlier this week, is my responsibility, as well as the government's new Help to Grow digital offering, which will be launched soon, which is our grants for software packages, if people are not aware of that. And that will go live on the 1st of December. Another area that I'm also looking after is, which might be of bit more interest to participants is audit reform. We consulted in the summer on a very extensive package of audit reform. We've received hundreds of responses to that consultation, and we are currently going through the policy options, taking account of some of the points that have been put to us. And again, in the near future, we will announce our preferred options before we have to proceed to the legislation to implement a number of them. Another area that I'm working on at the moment is those, again, who are involved in international investment, where currently we passed legislation called the National Security and Investment Act last year, and that is now being implemented. So we are setting up a new investment screening unit in BEIS, for which I have responsibility alongside the Secretary of State for the screening of all inward investment proposals, takeovers, allocations of intellectual property, etc., for UK-based companies. And it actually gives the Department of Secretary of State lots more power to intervene in mergers and acquisitions directly. And we're currently setting that up, and that will also go live on the 4th of January next year. That will supersede many of the powers that we have at the moment under the Enterprise Acts. That's probably a short summary of some of the things that I have responsibility for. And at the moment, a lot of our attention as business ministers and BEIS and everything else, of course, is dealing with the effects of the massive increase in gas prices that we've seen on the international markets. That's severely affecting many of our particularly energy-intensive industries, and causing some of them great stress at the moment, as a number of them, of course, have hedged their energy purchases throughout the winter. Some unfortunately haven't, and therefore they're in severe difficulties. So we are currently in discussions with a number of them to see what we can do to help. Of course, there's also been some dramatic changes in the domestic market. We've seen a number of smaller supplier companies go out of business. We have a process called a supplier of last resort that we implement through Ofgem, which basically takes the customers of those companies and gives them to some of the other suppliers in the market, so that people don't see any interruption to their supply. There are other powers that we also have if any of the bigger suppliers do go under, but we're very carefully and closely monitoring the market at the moment to ensure that the massive spikes that we've seen internationally don't add too adversely affect customers. There's nothing we can do about price increases, but we can make sure that continuity of supply is maintained. That's probably enough for me. They're the main issues that we're dealing with at the moment, but I'm very much looking forward to taking part in the panel.
That's great. Thank you very much. That's very informative, Lord Callanan. Well, I'll move on to my presentation on the bill, which just explains the detail of it and the rationale behind it. So the first slide, after the introductory slide, just shows the passage through Parliament that Lord Callanan alluded to, and the bill has had its second reading in the House of Lords and has the stages set out on that slide to go through. As stated, I think it's pretty uncontroversial. When it went through the Commons, no MP spoke against it, and there were no amendments proposed to it. So I think we can assume that it's going to become law, and it will be applied retrospectively. So at the moment, dissolving a company is a straightforward process and merely requires a majority of directors to sign a form DS-01, pay a £10 fee, upon receipt of which Companies House will publish a notice in the London Gazette. And if no objections are received, the company will be struck off 2 months after the publication of a further notice. I think there's been fairly widespread concern that the dissolution process is open to abuse, with directors misusing it either intentionally or otherwise. The Insolvency Service receives numerous complaints annually that the process has been abused. The most common being phoenixism, whereby directors dissolve a company to escape its liabilities, but start again, often from the same location with the same assets. Following the COVID pandemic, the government has been increasingly concerned that the dissolution process was being used as a means of fraudulently avoiding repayment of government-backed loans such as B-bills and C-bills. Directors may also choose dissolution to avoid investigation into their conduct pursuant to the Company Directors Disqualification Act 1986, which provides powers of investigation and the ability to apply for a court order to disqualify a director for up to 15 years. There are shortcomings in existing powers to investigate and disqualify directors of dissolved companies. In order to do so, it's necessary to apply to restore the company to the register, appoint a liquidator under Section 108, or use Companies Act powers to investigate and then seek a disqualification order, a fairly time-consuming and cumbersome process. The new bill seeks to close the loophole by extending the powers of investigation and disqualification to former directors of dissolved companies. It also provides that court orders can be made for compensation against disqualified directors whose conduct has caused a loss to creditors. However, I see certain limitations around the use of the new bill when it becomes an act and is enforced. At the moment, Companies House, the Insolvency Service disqualify about 1,200 directors each year based on the reports submitted in insolvency proceedings or public interest matters. In relation to BBLs, there were 2,000 companies that applied for strike-off the day after obtaining a BBL. In the quarter ended June 2021, as the slide shows, there were 371,705 companies in the process of removal from the register by strike-off or liquidation, and obviously the vast majority of those are through strike-off. And so I'm not sure whether the Insolvency Service will have the resources or the will to increase numbers significantly over the current levels. And my own view is the level of fraud around the government schemes is pretty large and will warrant disqualifications, either of those that apply to for their companies to be struck off, or those that have abused either the application or the use of the funds once received. So I think it's watch this space. In any event, I would always recommend that directors seek professional advice before applying for strike-off. So that ends my session on that bill. I'll now pass on to my colleague, Dave Rutter, who will talk about the finance availability in the current market. Dave.
Many thanks, Martin. Good afternoon, ladies and gentlemen. I think it's fair to say that without the financial support provided by the government, one wonders what would have happened to many firms in the UK over the past 18 to 24 months. I think we'd all agree that the funds injected into the economy certainly prevented many firms from ceasing to trade and provide a much needed lifeline. Over the next few minutes, I'm going to look at the replacement support scheme following the withdrawal of the BBLs and CBILS facility and what other facilities are available to the SME market today. As a brief reminder, this slide just shows how much support was given to the business community, with total funds injected to the tune of 76.3 billion to around 1.7, 1.8 million businesses across a range of sectors. With so much support being available in a relatively quick time frame, it's not surprising, perhaps, there are a few fraudulent claims that slip through the net. So the replacement for Bibbles and Sibbles offering was the recovery loan. Currently, there are around 75 lenders that have been accredited to the scheme, which is down from well over 100 previously. Additional lenders may join the scheme. However, due to the fact there is certainly more stringent rules in place, one wonders if lenders will wish to take advantage of the offering and join the scheme at this stage. Although, and I'm sure you can confirm, rumours have it that this will be extended for a further 6 months, or so said in one of the papers yesterday. We should remember that although lenders may be accredited, they will have their own lending parameters, and these will be dependent upon their investors or their funders who they borrow from for their own appetites to lend in certain sectors. From my own experience, the tier 1 banks are being very strict and selective to whom they wish to lend to. The fintech lenders do appear to have greater flexibility. However, clients in general will be paying higher rates to secure funding, and like the banks, any applicant who qualifies on normal commercial terms may be made an offer on that basis, as opposed to the recovery loan. For all to see, the key highlights are shown on the slide. However, as mentioned, do remember that each lender will have their own appetite and as such may impose their own lending criteria. With the exception of the high street banks, very few lenders will be offering all of these facilities. The vast majority of lending will be done on a straightforward term loan basis. I've just highlighted a few of the key differentials from the borrower's perspective. There is no longer an interest-free period or capital repayment holiday. With previous schemes, the government picked up any setup costs, but these now have to be paid by the borrower. For loans less than 250,000, no PGs will be required. However, security may be. Again, this is lender driven. Where new starts or companies with low turnovers missed out previously, again, subject to the lender's appetite, there may be opportunities to raise funds going further forward. If you need any information, please do contact me. So what is Aversible in the marketplace? Well, due to the success of the Bibbles and Sibbles, excluding what possible fraud may have taken place, and the historical fall in sales, a large number of funders have capacity to lend and are actively looking to do so. With the repayment of the government schemes now kicking in, problems with securing staff or supplier issues, many clients may or will have cash flow issues and will need to be aware of what is available to them. As we've seen recently, there is still nervousness in certain sectors, with the usual questions still being asked: will another lockdown take place? Concerns are for the hospitality and retail sectors and what impact this will have on them. Both the residential and commercial property sectors are very active. Development funding is available to developers through the high street and specialist lenders, but are all dependent upon the area where they are developing, as certain funders take the view that certain areas have become overdeveloped. As mentioned on the side, in the invoice finance space, despite well-known names pulling out, there are a number of new funders who've recently entered into the sector, and it'll be interesting to see how they progress in what is a crowded marketplace. I think it's one point that's worth mentioning is that some lenders are reassessing their appetite in certain sectors, which has resulted in facilities being held or reduced, and their customers being asked to source alternative funding solutions. This is irrespective of whether the customer is long-standing or profitable, which begs the question, why is this happening? It would appear that despite having funds available, certain funders are being very selective in which sectors they wish to support. So just to summarise, not all UK businesses will wish to or be able to utilise the recovery loan scheme. So I've indicated above where we've raised funds for clients over the past 12 months. In general, for businesses looking to expand their fleets of vehicles, invest in new modern machinery, we've utilised asset finance facilities secured by a hire purchase or leasing facilities. We recently secured leasing facilities for a London-based accountancy firm to refit their new premises. For new starts and or expanding businesses that need to improve their working capital cycle, we've secured facilities with a number of invoice providers. Many of these been in the supply of labour in the hospitality, healthcare, and construction sectors. Where we've had businesses that need short-term funding, we've introduced them to providers of revolving credit facilities, and clients who are paid by credit card, such as many retail venues, we've secured finance through providers of merchant cash advances. Bridging is still being used for a multiple of reasons and secured against property, normally over a short term. Again, we've assisted clients here. The banks and numerous funders are still keen to lend on good credits. And with regards to commercial property, we recently committed a £10 million facility for a client. Finally, where clients need to fund goods to be released from the Far East, or where suppliers demand cash prior to delivery, or those who have funds tied up in stock, we can provide funding with specialist lenders in this sector, be it trade finance or stock finance. On this point, early this year, trade finance was utilised to allow an importer to secure ladies' garments being manufactured in Morocco, where they had to pay full price upfront before goods were being released. And this is not uncommon when goods are coming from abroad. Depending on your clients, they may wish to use one or more of the options, and as such, please contact me for further details. Hopefully that's given you a brief insight of what is available in the market today, and many thanks for your perseverance. I'll now pass you back to Martin and the panel.
Thanks very much, Dave. And although it is a sales plug for Dave, I do want to emphasise that the market for finance is ever-changing and fast-moving. Really has changed from years ago, where the clearing banks had a grip. The secondary lenders, the fintechs, etc., have changed the market, and they're looking for business and changing their terms all of the time. So it really is worthwhile getting in touch with Dave if you have finance requirements to understand what the current situation is. We'll now move on to the panel session. As I said, we've had a number of questions submitted in advance, and we'll work them around the panel. So the first question is, what are the concerns for businesses as we head towards 2022, taking into account supply chain issues, staffing, potential for further lockdowns, as well as financial concerns? And if I can start with you, Lord Callanan, on that question.
Certainly. There are a lot of different concerns. A lot of it depends on whichever sector the business is in, of course. I mean, you mentioned the difficulties of the hospitality sector, and this is an area in government that Paul Scully has responsibility for, and I know he's always doing lots of meetings and engagement with the sector to try and see what we can do to help in terms of their concerns. I mean, I mentioned the issue of energy prices earlier. That is massive concern for particularly some of the, as I said, the big energy intensive industries. We are experiencing a number of supply chain difficulties as well, primarily driven by shortage of HGV drivers. We're taking action in a number of fields to try and do that. We've issued more visas. We're trying to get more people through their various tests. We've extended the proposals for cabotage to provide more capacity within the UK. And the DfT, I know, is engaged in a number of different actions to try and alleviate that. There are still ongoing supply disruptions across the world. Firstly, because of obviously the pandemic, changing in trade arrangements, etc., is disrupting the particularly shipping cargoes. I was talking to a business last week. It was the price for shipping containers has gone through the roof over the last few months. Actually, incredible increases in cost. So they're all of the concerns that, and I can say in terms of lockdowns, it's very much the Prime Minister's intention to avoid, if at all possible, any further lockdowns. I mean, it's ruinously damaging to the economy and to business. So we will do all we can to try and avoid that.
Yeah, thanks. Prav, if I can put the same question to you, I know you speak to lots of mid-size and large-size corporates and banks.
I think the only thing I'd add possibly was the changes to working cultures as well. It's very difficult to roadmap where things are going to end up, and that's going to have the impact on particular sectors like hospitality, leisure, and also the landlord issues as well, landlord and tenant issues, I think.
Sure. Andy, we speak to lots of SMEs in particular and some larger size businesses. What are you finding?
Yeah, I think it's you probably cover it with just uncertainty generally. I think, as Lord Cullinan mentions, there's sector-specific issues. Businesses just don't know how they're going to recover or bounce back now that we're out of lockdown. And as Prav mentions, there's this behaviour. Consumer behaviour is just very uncertain, and these strange occurrences that come up that you can't quite predict at the moment. It's difficult for businesses. And then in terms of dealing with liability, so if you're looking at the financials, it's what's going to happen in the new year. So in terms of the arbitration scheme with rent arrears as well, what are HMRC going to do in terms of pursuing their own liabilities? There's lots of these sort of questions that nobody knows the answer to at the moment.
Sure. Okay, the next question I have is, what are the most significant trends in the UK corporate insolvency and restructuring arena over the past 12 months or so? If I could put that to you, Prav.
Yeah, I think in the last year, since the start of the pandemic, we've had a number of new legislation. We've had the Corporate Insolvency and Governance Act, which has introduced more restructuring options, such as restructuring plans, moratoriums, suspension of wrongful trading, suppliers and ipso facto clauses for suppliers to continue providing services or supplies, restrictions on landlords and creditor action in respect of commercial rent arrears, and restrictions on winding up petitions. We've also seen some other legislation, such as the Finance Act, powers for HMRC to pursue directors personally if there's been phoenixism or evasion or avoidance. We've also had the reintroduction of Crown preference. The Pension Scheme Act has come in, which increases moral hazard powers and investigatory powers. We've also had the introduction of the pre-pack pull for sales, pre-pack sales to connected parties, and need to be ratified by an evaluator. So the last 12 months have seen a number of procedures and processes that have been implemented, which has been pretty unprecedented, I think. Sure.
Lord Cullinan?
I think Prav has summarised it extremely well. I was just going to say the only thing he hadn't mentioned was pre-packs, but he did mention it at the end. So I was involved in the regulations for that. But there's a lot of parliamentary pressure, particularly on pre-packs and some of the more egregious examples of abuse of the process.
Sure. Andy?
Yeah, I was just going to say it's a fairly long list Prav just produced, actually. Of the ones that are, I suppose, interest, if I was looking forward, at things like the moratorium and restructuring plans. So this standalone moratorium that enables businesses or companies to benefit from this protection, whilst you need this belief that the company is going to come out the other side as a going concern. So that may be of use. I know that's not been used a lot at the moment. And then in terms of the restructuring plan, it'd be interesting to see if that in a way replaces CVAs to some extent with the larger entities. So again, there's been talk of that being used for smaller businesses or smaller medium-sized businesses. So that would be interesting to see how much that is used going forward.
Okay, thanks. The next question we have is, there's been a recent increase in the number of insolvency cases. The last month published figures for September were, I think, just over 1,300, but that's still not back to pre-pandemic levels. And for the last 15 months, the number of formal insolvencies have been at record lows, probably for the reasons that Prav alluded to. What trends and developments do you expect will dominate in the space going forward, and what changes are we likely to see? So Andy, if you start with that, please.
Yeah, for the time being, I can see those trends continuing in terms of a lot of creditor voluntary liquidation. So where that director initiates that process of putting the company into liquidation. We've seen a large number of those because of, well, prompted and triggered by bounce back loans becoming repayable and then the furlough scheme ending. So I can see that continuing for the time being. I think a lot of what's going to happen is going to be dictated by HMRC and how they start their enforcement action. So I think they're in this difficult position where they don't want to be seen to be too aggressive. But equally, from what I'm seeing with a lot of businesses, is they are generally still the last to be paid because businesses are paying their suppliers and now paying the bulk of the wages because the furlough scheme isn't there anymore. And that is the priority for the business in order to keep it trading. And unfortunately, that means that in some cases HMRC aren't getting paid. So I think they may well be the largest influence in terms of what happens to companies going forward. The other thing is I suspect we will now see increases in court winding ups and potentially bankruptcies as well, where there are contentious issues there that need to be pursued, and creditors have now got the option to pursue a winding up petition. I mean, the only other comment I'd have is from anecdotally speaking to solicitors where they're issuing winding up petitions, is that they're finding a lot of them are getting paid at the moment they've issued those petitions. So that'll be interesting to see if the numbers go up considerably, or you'll find that a lot of those creditors are starting to pay up at the moment there's enforcement action.
Sure. Dave, if I can put that to you, I know you speak to a lot of lenders and they have their own internal position.
I think certainly, Martin, the lenders in general are beefing up in their recovery teams because there's a lot of concern of what's going to happen going forward. And I think just to allude what I was saying on the presentation is that tier one banks, where they've been dealing with customers for many years, if they feel that their security is at risk, they are changing those profiles, and you are seeing that customers are being put under more pressure to either move out of certain sectors where the bank feels uncomfortable in funding that part of the business, or actually rebanking and going to another funder. So there does seem to be an awful lot of nervousness within the financial sector, and it'll be very interesting to see what does happen over the next 3 to 6 months. But again, as we spoke about earlier on, certain businesses cannot grow because they just simply cannot get the staff. You know, we've got clients who are in the hospitality, who supply into the hospitality sector. We've got clients who provide drivers, and they just simply cannot get drivers or cleaning staff to carry out the work. So how are they going to be impacted? They've got to downsize. How long they downsize for, one doesn't know. Their creditors will need to be understanding, I think.
Sure. Prav?
I think one of the interesting things about these statistics was I think it was only over 90% was in relation to CVLs, so creditors voluntary liquidations, which suggests that there's a tendency for directors to bury the businesses as opposed to rescue procedures such as administrations and CVAs. I think it'll be interesting to see over the next few months what the position of landlords and tenants are, because the introduction, I think, in spring of the mandatory arbitration process, whether that's going to lead to a flurry of court actions to try and fix the judgments in terms of any rent arrears, whether that's going to happen over the next 6 months or so.
Thanks. And Lord Callanan?
I don't have a lot to add to that from a government point of view. What I think has been pleasantly surprising is how relatively few insolvency cases there have been. One of the reasons for the Corporate Insolvency and Governance Act was to deal with what we expected would be a flood of insolvency as C bills and B bills were withdrawn and furlough payments were ceasing. We expected there to be a lot of companies sadly going down, and we've been pleasantly surprised by how relatively few there have been so far. I think it's a great sign for the resilience of the economy. In terms of developments going forward, we need to look at the provisions in the Insolvency and Governance Act and decide whether to continue some of the temporary ones or not. And particularly, as you can imagine, are getting a lot of pressure from landlords who are concerned about the provisions that, as they would say, adversely affect them.
Yeah, understandable. I mean, perhaps a comment I'll add on that around the government support schemes, which are of course fantastic. But I think there was potentially an unintended consequence that by providing B-bills to smaller businesses and giving effectively extended credit from HMRC with little chasing or enforcement action, it has potentially propped up businesses that were insolvent pre-pandemic. The next question is, have we seen much evidence of fraud? So, Dave, if I can start with you, because I know once again the lenders have experience of fraud, in particular in invoice finance.
Certainly, in the invoice finance sector, fraud has increased, no doubt about it. And again, why they are now beefing up their recovery teams, because they're going to need to pursue and chase the directors for the acts that they have committed. But I also think, Martin, that the banks in themselves, in terms of the bounce back loans, I think it came to light very quickly that there was vast amounts of fraud that have taken place. Obviously, that falls into your remit going forward. But I think where banks and funders are concerned is that because perhaps some of their due diligence was quite slack in the early days, is that if they need to call upon the guarantees that were provided by the government, they're going to be very concerned that they may not be able to call upon those guarantees where they've fallen down on their own due diligence. Going forward, I think all the lenders are going to be very careful on their existing portfolio and taking on new customers who are moving across from other funders. And often they're moving across to hide the fact that somewhere in the background, some form of fraud has taken place.
Sure. Prav?
I don't think I have much to add. I think I've seen it in the context of bounce back loans and furlough schemes. And obviously those issues are sort of coming to light now, aren't they?
Sure. Andy?
Yeah, I would just add, I can see it's going to be a big area, I think, and in particular for insolvency practitioners to coming across it a lot on our cases. I think it's going to take a while to be flushed out. A lot of them will come through with things like compulsory or court winding ups, where these people are, if they've got an opportunity to commit fraud, then those types of people would have taken advantage of the last 18 months or so. So I'm sure we'll see it a lot on our cases.
Yeah, I mean, I think we have seen already, and I mean, to be fair, I think the government expected this, that there would be a degree of it. There was obviously a criminal element to it that attempts were made to prevent, and of course only half of the applications were actually accepted of the overall applications for B-bills, and so I think that the sort of real criminal type would have been prevented in many cases, but I think there will be a lot of cases where it's happened not necessarily intentionally, but people have abused the process. But Lord Cullinan, do you have anything to add on that?
Not a huge amount. I mean, yes, we have obviously seen an increase in cases, and that's obviously one of the reasons why we introduced the bill that you mentioned at the start of your presentation, Martin. We always expected that there was going to be an element of fraud. All of the loans and recovery schemes and furlough scheme were introduced extremely quickly. There was no time to do extensive testing and the normal processes that you go through in government before introducing any guaranteed loan scheme or grant scheme, etc. The extensive fraud checking and lots of different steps to go through. All of those were circumvented because of the urgency of the problem. And certainly senior officials said that, warned ministers that you're doing this, people will take advantage of it, unfortunately. But the overriding view was just that we just needed to get the finance out there to support business during a dreadful time. So we knew that there would be an increase, and obviously we're doing all we can through recovery efforts and through the legislation that you spoke about earlier to try and recover the money, which at the end of the day is taxpayers' cash.
Yeah, of course. I mean, it actually leads nicely on to the next question that we had sent in, which is the lockdown fatigue for business owners, which mean that long-term time to pay arrangements, CVAs, etc., are not feasible. And I think that's in light of the fact that people can pay back B bills or C bills over 6 years with various 6-month breaks, either for interest or capital repayment. HMRC seem to be offering long-term repayment plans over up to 3 years or maybe even longer. And I think the question is whether businesses have the appetite. They should have the moral responsibility to repay it, but whether they have the appetite to work hard for 3 or 4 or 5 years just to repay debt. So Prav, perhaps if I start with you.
Yeah, almost certainly. I think often directors are faced with significant arrears or long-term repayment plans, which are premised on an expected level of trading as well, which is, as we've discussed, is uncertain. So often, I think one of the options for directors is an insolvency process, which allows them to start again. We've also seen issues with CVAs and restructuring plans, and as we mentioned before, not often available to certain the SME market, which are generally utilised by some of the bigger companies as well, which allows them to compromise their liability. So we've definitely seen that there's been some director fatigue, I think.
Lord Callanan, once again, I know you engage with business groups and many businesses.
And there is obviously a certain amount of fatigue, but we're again trying to do all we can to persuade people to trade through the difficulties to carry on. And it would be a tremendous shame if viable businesses went down because of that. And I can't obviously comment on HMRC's policy. You will understand that. I only hope that they are being as forgiving as possible for the taxman in terms of helping businesses to trade through the difficulties.
Sure. Andy?
Yeah, I would just add, I think, the time to pay seems to be, it's attractive to a lot of the business owners that I speak to. I think it's making that process as smooth as possible and probably as clear for business owners so they can understand what's feasible in the circumstances. Some of those are going to have to be very long term to enable businesses to be able to repay those liabilities. In terms of CVAs, I suspect that at the moment they're not so attractive because of the commitment to pay contributions over, say, 3 to 5 years, whilst this uncertainty is out there in terms of future performance and what they can commit to.
And of course, the reintroduction of Crown preference from December last year has had an impact on CVAs and IVAs. Dave?
Well, I just reiterate what Prav and Andrew have said. It's the uncertainty of business owners if they go through a pre-pack process and they've got to carry debt for a number of years. With respect to it's their ongoing liabilities, and I think the fact that with the uncertainty, they're probably very reluctant to try and entertain a process. They go through the process and have debt hanging around their necks for another 4 or 5 years, with the uncertainty of what may or may not happen in the marketplace. And I think that's their biggest concern. It's just not knowing what's going to happen. And funders themselves are being very, I think the right word, of being very careful in looking to support certain pre-packs, because they too are very aware of the uncertainty. So probably there are businesses that could go through processes like this that have got a very good chance of survival, but because they can't get the backing from certain lenders, they won't entertain it.
Okay, I think the next question we have is one that I'll start with Prav, is what impact have recent court rulings had in the insolvency space, and how are the issues the cases involved likely to affect how parties conduct themselves going forward?
I think some of the main case law has been in relation to restructuring plans and the CVAs, the treatment of landlords in relation to CVAs. And what we've seen from some of these cases is that the court have got a tendency to probe some of the commercial issues a bit more. With the restructuring plans, for example, looking at the relevant alternatives, with the CVAs about how certain liabilities are being compromised and testing those issues as well. We've also seen that some of the case law in relation to the winding up restrictions, where the court have given a wide interpretation as to what COVID related debts are, which is probably more debtor friendly than creditor friendly. And also we've seen with all the court backlogs as well, and the possible introduction of mandatory ADR, the possibility of parties seeking to resolve disputes earlier, possibly consensually. We've talked about time to pay arrangements and payment plans to avoid court or litigation if possible, because there are backlogs in courts and listing periods in certain courts are obviously awaiting a long time.
Sure. Lord Cullinan?
To be honest, I don't have anything to add to what Prav has had to say on this one.
Okay, thanks, Andy.
Yeah, I was just going to, what Prav was saying in terms of CVAs and restructuring plans, it's been interesting. In terms of the restructuring plans have been used to, I think, compromise some of the landlord liabilities and deal with leases. And my understanding is none of those have been appealed at this stage because it's a court ratified process, whereas with the CVAs, and there's been a lot in the press about the retail CVAs where they've been used for the same reason in order to deal with landlords. Some of those have been appealed, and although they have gone in the company's favour, it's still hugely disruptive to a business to have to think about, I'll go through a CVA, but is this likely to get appealed? What impact does that have on the business while this is going on? And CVAs are already slightly unattractive for these other reasons that we've discussed. So I wonder, what impact that is going to have on the attractiveness of CVAs going forward compared to, say, a restructuring plan, which gives us a bit more certainty, it seems, in terms of an outcome.
Sure. Okay, then the next question that we have is one that has been touched upon, but it's are further insolvencies in the energy sector over the coming months likely? And do you think the rescue remedies available to energy suppliers in difficulty are fit for purpose? Lord Cullinan?
Yes and yes. I need to be very, very careful what I say here, obviously, as you can imagine. But sadly, yes, we are expecting further insolvencies from energy suppliers and other people involved in the sector. We have, as I said earlier, we have the supplier of last resort process, which we administer through Ofgem. And for larger suppliers, we also have the possibility of a special administrative regime as well. I can't say any more on this, sorry.
No, sure, I understand. Prav?
Well, I think we've obviously seen in this year a large number of energy companies that are facing insolvency. And as Lord Callahan mentioned, under the Energy Act, Ofgem as regulator oversees this implementation of this supplier of last resort to allow customers to be transferred over to another provider without any interruption. I think, as I understand it, before 2021, there was 2 energy insolvencies. Obviously, I think we're looking at something like 15 or 20. One of the concerns is obviously these smaller energy suppliers were increasing competition in the market. And it seems that the suppliers of last resort means that the big 6 energy suppliers are taking over these customers, I think.
Sure. Andy?
No, I don't have anything to add. I suppose the only thing in terms of gas prices, I'm encouraging my family to wear their jumpers and turn the lights off more. So practical comments rather than
Is that due to COP26 or saving money?
saving money.
Right. the next question we have sent in is, are landlords being treated fairly, and how do we expect the new arbitration scheme to work next year? And Prav, I'll put that to you because I know you represent both landlords and tenants.
Yeah, so as I understand it, I think the business secretary said that the intention was to provide commercial tenants and landlords with peace of mind that COVID-related debts will be settled fairly and with finality. And as I understand it, the process is an expedited determination via a binding arbitration as a last resort. And there's an encouragement for early dialogue between the parties, consideration of repayment plans. It's unlikely, as I understand it, for this to be implemented before spring of next year. I think one thing we're not sure about is whether a number of landlords will be taking action before then in order to fix their liability. We've seen an increase in measures by landlords either trying to use winding up petitions or by trying to use normal litigation and summary judgment to fix the liability. I don't know whether, I mean, obviously landlords are complaining that this is unfair. I think there is a sort of a rebalancing, as we've seen with some of the case law with CVAs. I think it's something to watch over the next few months, I think.
Yeah, sorry, as far as you're able to, Lord Callanan, do you wish to comment on?
I can say that lots of landlords are writing to me saying they're not being treated fairly. It's a difficult balance to get right, isn't it? Obviously, we want to try and restore their rights to take actions to recover their rent. There are some examples that have been sent to me of perhaps tenants abusing the process, not being entirely fair with the landlords. Is one particular big example at the moment, which I won't go into any further details on. And we keep this situation under review, and whether it would be right to phase out the powers under the Corporate Insolvency and Governance Act.
Sure. Dave?
It's just the impact that it's going to have on, where you've got property investment companies that rely on rental income, how the banks are going to view the lending position of those going forward until there's a clearer picture, because that will stagnate that sector, and the banks in general, unless they're very happy with the very, very good, strong covenants, they won't look to support that sector. That's all I can say.
Thanks. Andy?
Yeah, I would just say that it seems to have been a bit of a mixed bag in terms of those relationships between tenants and landlords. Like we said, some tenants refusing to pay and perhaps unfairly, and then at the other end of the scale, with perhaps some landlords not showing a willingness to compromise some of those liabilities. I was just going to raise a question with Prav, actually, and just in terms of the arbitration for next year, because there seems to still be some uncertainty with that. But in terms of the periods of rent where they may fall into that arbitration and they might be compromised, what I'd heard was that only relates to those periods where they were in lockdown and they weren't able to trade, whereas those other periods perhaps where certain restrictions are in place, there seems to be a bit of a grey area in terms of how they will deal with those periods of rent arrears.
I don't have any. I've heard that as well. I don't have any intel whether on either of those aspects, unfortunately.
Okay. The next question I'll exclude Lord Callanan from. It's how will HMRC approach cases later in the year, and what's the latest with time to pay arrangements? Andy?
Well, the latest I'd heard in terms of time to pay was that there was a willingness to extend them to kind of 5 to 7 years, is what I'd heard via representatives from R3, so our kind of representative body. Yeah, I think I mentioned it earlier that I think they're in a difficult place in terms of not wanting to be seen to be too aggressive, but equally needing to protect themselves and look after these ongoing liabilities that might be building up. So I think for clients, it's all about communication with HMRC, and that's what I encourage clients to do if they've got arrears and they're in difficulty. It's getting in contact with HMRC, seeing if they can set up payment plans, and that seemed to be the message coming out from government to try and do that. And I think businesses will run into trouble where there's no communication and they're not cooperating. I mean, we've had recent cases where we've seen HMRC looking for security deposits where there's concern over compliance, historic arrears. So again, that's another weapon they've got there to go to businesses and say, look, you need to behave reasonably and pay where you can, and they're willing to do time to pays. But I still think there should be a space there for them to take enforcement and look for winding up petitions where there is poor compliance and huge arrears.
Sure, Prav?
No, I'd agree with that. I mean, early dialogue is encouraged. I think the cases where we see that it's often the case where there's been no updates, there's been breach of agreements for time to pay, and that's the area when you feel that HMRC have to flex their muscles in terms of enforcement. But I think if you keep them updated, I think they'd understand some of these issues. So as Andy says, it's about dialogue.
Yeah, I mean, I'll add from my own experiences. I agree entirely with the comments you've made. I think one of the difficulties is actually necessarily having dialogue with HMRC, is finding the right person to speak to, or someone that's familiar with the case is often an issue in the first place. And probably unsurprisingly, with an organisation the size of HMRC, there's complete inconsistency of approach to different types of cases, and that's something that probably needs to improve. By way of example, we did a pre-pack for a cleaning company it was exactly the right thing to do, because it was a cleaning company that provided its services to hotels. Its turnover went from over $1 million a week to zero at the beginning of the pandemic, unsurprisingly. The business and a lot of jobs were saved with a pre-pack, and very shortly afterwards, HMRC issued a request for a security deposit for more than the company's turnover was going forward. So, as I say, I think there just needs to be a consistency of approach. That's my own view. Look, I'm conscious we're coming to the end of the time, and before I thank all of the guests, there are a couple of points. One very serious one. First, it's exactly a week since the attack and murder of Sir David Amess, one of Lord Cullinan's Conservative colleagues, and I'm sure we're all united in our outrage at this attack on our democracy, which mustn't be allowed to succeed. So that's what I wanted to say on that. And then moving on to a much more frivolous and irrelevant point, taking into account where Lord Cullinan hails from, I'm just going to ask everyone's views on the prospects for Newcastle United after their takeover. Lord Cullinan.
This is something in which I definitely declare an interest. I'm a season ticket holder at Newcastle, so I'm hugely excited for the new era. Let's see how it all pans out. Slightly, some of my fellow fans think that huge quantities of funds are going to flow into the club immediately, and of course that can't happen under financial fair play provisions. I don't think it would be right to do anyway. Then they need to build up the whole infrastructure and approach it gradually. And I think, to be fair, so far the new owners have set out that they want to have a gradualist approach. They fired Steve Bruce last week, although before you feel too sorry for him, I think he walked away with about an £8 million payout or something. So I'm sure he's going to be, well, probably not crying into his drink, but he'll survive. He'll be able to buy plenty of drinks with it. And yeah, we'll see. And I think it's obviously hugely it's good for the club. Newcastle gets regularly 50,000 supporters at the games, and it'll be great to see them have a bit more ambition than just survive, which has been the options for the last few years.
Yeah, well, we're all football supporters on this. So, Prav, as an Arsenal supporter, your view?
Oh, interesting to see who the new manager will be. But no, I'm pleased. I mean, it's a great football club, so no, I look forward to it.
Andy, as a Charlton supporter.
Oh, I can't say anything about any other football clubs.
And Dave, as a Palace supporter.
Oh, I would just love to see Palace be able to fit 50,000 people in the ground, which is very pleased, to be honest with you.
I actually went to the Palace Newcastle game a couple of seasons ago at Palace. I think you have some improvements that you need to make to the stadium, would be my comment on that.
I'm sure plans are underway.
Well, good luck to all of the clubs. In any case, that brings this webinar to a close. We're enormously grateful to Lord Callanan for stepping in as a replacement for Paul at the very last minute, and to Prav for joining us today and for his wisdom on many subjects. And thanks to all of those who have attended live. And if you have any questions or require advice, do please get in touch via the website or by phone. This recording will be posted on our website and will be circulated to the database. So thanks, and I'll bring the session to a close. Thank you.